Hello, class. We're going to talk about agency liability in this video. We're on chapter 33. This is part 2. First, we'll look at the principal's liability, and I want you to remember when we're talking about the principal's liability, it's going to be based on whether the agent has authority to act, and 2, whether the principal is known or disclosed to the third party with whom the agent has interacted. So regarding the status of the principal, there are 3 possibilities. The principal can be fully disclosed, meaning the principal is known to the third party. Right? The principal can also be, or could also be, partially disclosed, meaning their identity could be hidden. So if a third party doesn't know the identity of the principal, but knows the agent is representing someone, the principal will still be liable. And in some states, the agent is also going to be liable. All right. A good case for that, for you to just have some reference, is case in point 33.8. This is the case of Stonehard, and I'm going to switch out to it in your textbook, put it on the screen for you. Let me just adjust my notes a second first. All right. Let me change out on the screen. Here it is. All right, so let me read you the facts. All right, Stonehard makes epoxy and urethane flooring and installs it in industrial and commercial buildings. Marvin Sussman contracted with Stonehard to install flooring at a Blue Ridge Farms food manufacturing facility in Brooklyn, New York. Sussman did not disclose that he was acting as an agent for the facility's owner, Blue Ridge Foods, LLC, at the time of the contract. When Stonehard was not paid for the flooring it installed, it filed a suit against the facility, its owners, and Sussman to recover damages for breach of contract. The lower court dismissed the complaint against Sussman personally, but on appeal, a reviewing court reversed that decision. The contract had been signed by Sussman of Blue Ridge Farms. That evidence indicated that Sussman was acting as an agent for a partially disclosed principal, in that the agency relationship was known, but not the principal's identity. As an agent for an undisclosed or partially disclosed principal, Sussman became personally liable under the contract. I just realized, class, I didn't adjust my lighting, so let me just quickly do that because I think it must be pretty hard to look at the lighting behind me. Hold on a second. Excuse me, my production quality not too good right now. All right, so let me just go back and talk a bit about this case, Stonehard. All right, so we have an agent acting on behalf of his principal, Blue Ridge Farms, but he didn't say that he was acting on behalf of Blue Ridge Farms as their agent. The only thing he did was sign the contract that way. He said Sussman of Blue Ridge Farms on the contract. And so that was enough, though, for the court to say that he had been partially disclosed. He had partially disclosed his principal. He's a partially disclosed agent as well. And so because of that, not only is his principal going to be liable, but he himself, the agent, will also be personally liable here. Okay, so unfortunate for him, but a good lesson for us in terms of what do you do when you're an agent. You always want to fully disclose you're acting on behalf of a principal and who that principal is. All right, let me switch back to my slides and we'll look at the third possible situation, which is when you have a totally undisclosed principal. That means that nothing has been said by the agent to the third party that he is representing somebody. All right, so the third party has no clue, does not know that the third party is dealing with some other person through this person that's talking to them. All right, The example for this would be this case in point called Williams v. Pike. And in this particular case, and I can take you back out to your book. I'm sorry, I'm switching back and forth quite a bit here. Slide down a bit. Here you go. In this particular case, Bobby Williams bought a car at Sherman Henderson's auto repair business in Louisiana for $3,000. Henderson, the agent, negotiated and made the sale for the car's owner, Joe Pike, the principal, whose name was not disclosed. Williams drove the car to Memphis, Tennessee, where his daughter was a student. 3 days after the sale, the car's engine caught fire. Williams extinguished the blaze and he contacted Henderson. The next day, the vehicle was stolen from a parking lot outside of Williams' daughter's apartment. Williams filed a suit in a Louisiana state court against Pike, the principal, and Henderson, the agent. The court awarded Williams $2,000 plus the cost of the suit, adding that if Williams had returned the car, it would have awarded him the entire price. All right, a state appellate court affirmed both Pike and Anderson, the undisclosed principal, and the agent were liable to Williams. All right, so you see what's happened here in these three cases. The principal has been held liable in each of them. In 2 of the 3, the partially disclosed principal and the undisclosed principal, the agent was also held liable. I'm going to switch back now to the PowerPoint and we'll continue taking a look at liability for torts and or crimes. All right. So regarding torts, the agent is going to be liable for his or her own torts. All right. The principal will be liable for the agent's torts under certain circumstances. So I've listed these circumstances here for you. So principal is liable if the agent's tort resulted from the principal's tortious conduct. So if the principal is given instruction, tell the agent to go ahead and do something, such as in this example, drive without a license. All right, that and there would be some tortious conduct there. All right, violation of the law there. So the principal's got to take responsibility for that. Okay. All right, second example up here, the principal authorizes tortious conduct by the agent. So again, there's some instruction or direction. So the principal tells the agent in this example, go ahead and cut that crop, even though the principal has no right to that crop. All right, so he's telling his agent to go against the law, to break the law here. All right, and then number 3, the agent's misrepresentation as authorized by the principal. Even if the agent doesn't know he's making a misrepresentation, all right, the principal authorized it though, maybe some statements about a product, some misrepresentation about a product, principal's got to take responsibility for the tort that the agent commits by following the instructions. All right, and one other scenario would be events that take place under the authority or within the scope of agency or employment, right? And the doctrine we use for this when an employee is acting on behalf of their employer is respondeat superior, all right? So that's a new term for you, perhaps, is on your vocabulary list. Please remember it, all right? So how do we, tell, how do you know that an action of the agent employee is within the scope of employment or within the scope of the agency? Well, there's some questions we can ask here. So letter A, 5A there, did the principal authorize the act? What time, when, and where did this act take place? Were the principal's interests advanced in any way? One thing that is excluded is travel time to and from work. So if anything occurs on that travel time, that is not within the employer's responsibility. It's outside the scope of the agency or outside the scope of employment. And letter E follows kind of along that line. Anytime you have what's called a frolic, and this is an old word, I don't think you hear this term very much, all right? But what it describes is anytime an employee is away from their job, they are doing something on their own personal time, they are on a frolic, right? That would also not be included within the scope of employment or agency. So sometimes, when you're traveling for your employer, you're on the road and you may take a detour to do something personal, or, you stop somewhere for lunch. That may not necessarily be within the scope of employment. All right. And so the argument comes down to how far off of the work or away from work was the employee. All right. Now, the reviewing problem at the end of the chapter is a good example to walk through these concepts, and we will take a look at it right now. This case in your book, asphalt and concrete services, is also another good example. You can read through that case, and it has a pretty long list the court used there regarding the circumstances of the work. So it was pretty clear, based on those circumstances, that the driver of the truck in this asphalt and concrete services case was within the scope of his or her employment, and so injury occurred in the accident that arose would be the responsibility of the employer in that case. But want to take a look at this reviewing problem. And this, I do have it typed into the PowerPoint. I must have had the time to type it weeks ago, but I always prefer to look at it in your textbook. Let me just move out there right now and get it up here on the screen. All right, reviewing problems are always at the end of the chapter. Here it goes. And I think this will help us to just illustrate quite well the principles we just finished talking about here. And I still have a few more points to make after this problem, which will help tie everything up. All right, so I'm going to read through the problem, and then we'll look at the 4 questions that follow it. Let me just adjust my slides here. Okay, all right. So Lynn Meyer was on her way to a business meeting and in a hurry. She stopped at Bi-Mart store for a new car charger for her smartphone. There was a long line at one of the checkout counters, but a cashier, Valerie Watts, opened another counter and began loading the cash drawer. Meyer told Watts that she was in a hurry, and she asked Watts to work faster. Instead, Watts slowed her pace. At this point, Meyer hit Watts. It is not clear whether Meyer hit Watts intentionally or in an attempt to retrieve the car charger, hit her inadvertently. In response, Watts grabbed Meyer by the hair and hit her repeatedly in the back of the head while Meyer screamed for help. Management personnel separated the 2 women and questioned them about the incident. Watts was immediately fired for violating the store's no fighting policy. Meyer subsequently sued Bi-Mart, alleging that the store was liable for the tort, assault and battery, committed by its employee. Using the information presented in the chapter, answer the following questions. All right, let's see if we can walk through these. Number 1, under what doctrine discussed in this chapter might Bi-Mart be held liable for the tort committed by Watts? All right, what doctrine have we just talked about? It's the doctrine of respondeat superior. Right? That would come into consideration here. Right, number 2. What is the key factor in determining whether Bi-Mart is liable under this doctrine? What did we talk about? We have to determine, was Watts acting within the scope of her employment? That would be the clearest way to tie Bi-Mart to the injuries now suffered by Meyer. Okay. All right. Number 3. How is Bi-Mart's potential liability affected by whether Watt's behavior constituted an intentional tort or a tort of negligence. All right, we may not have talked too much about this yet, but generally speaking, employers take responsibility for negligent acts of their employees while they're acting within the scope of employment. All right, so negligence, just taking a little too much risk, perhaps, not being as careful as they could have been or should have been. All right, but employers do not necessarily take responsibility for tortious acts, and actually that's what we said earlier too. Agents really are liable for their own torts, and not unless they've been authorized by their principal or somehow the principal has instructed the agent to take some tortious steps. All right, so depending on what we have in this situation, we probably do not have any authority from Bi-Mart to Valerie Watts to take the situation and beat up the customer the way she did. So they won't be responsible generally for her tort, the commission of her tort. All right, and then number 4, just want to move it up a little higher for you there. All right, number 4, it reads, suppose that when Watts applied for the job at Bi-Mart, she disclosed in her application that she had previously been convicted of felony assault and battery. Nevertheless, Bi-Mart hired Watts as a cashier. Now, how might this fact affect Bi-Mart's liability for Watts' actions? All right. These facts, you probably already can kind of consider this in your head, right? They would change the scenario sufficiently, wouldn't they? They change everything, because here Bi-Mart knows Watts has his past record and she has a conviction. She has perhaps a propensity for this type of assault on another person, and yet they hired her and put her out to work with the public. All right. Bi-Mart would have a lot more responsibility to monitor and supervise Valerie Watts than they might originally had in the original situation. All right. And so probably Bi-Mart would bear liability if this were the case in number 4. Right. A little bit more to go before I finish up with this section. Let me go back out to the PowerPoint and put the last slide for this part up on the screen. All right, and 2 points here, all right, to follow what we've been looking at in the Bi-Mart case. The 2 points are, first, letter C, principals liable for intentional torts and crimes that are committed within the course and scope of agent's actions on behalf of the principal. All right, so I gave an example here. Maybe there would be an apartment manager that goes around and collects rent from the tenants, and as a result of that, and this is where the principal has put the apartment manager into that scenario, there is some ruckus or some fist fight, let's just say, perhaps that tort, you could use it to find liability for the principal. Okay. All right, and then D, generally the principal is not liable for crimes by the agent, even if committed within the course and scope of an agency. All right, so it kind of depends on how much the employer has done to put the employee in a position, okay, and how much they know about the propensity of their employee. But generally speaking, principal is not liable for the agent's torts and or crimes. All right. So there are a few more problems I'd like to look at connected with the concepts in this section 2, part 2. They are business scenario problems 33.1 and 33.2, which will illustrate what we've just been over. And so I'll be creating a separate video along with a video for chapter 33, part 3 that will cover the termination of an agency relationship.